Tonight in the courts, the battle over a special master heats up after the FBI's raid at Mar-a-Lago. We take a look at state salary transparency laws, and we tell you who a guy named Fat Leonard is. First up, the Department of Justice is preparing to appeal Florida federal judge Eileen Cannon's order for a special master. Now, Cannon, who's a Trump appointee, also blocked the Department of Justice from accessing any of the records retrieved from Mar-a-Lago as part of its ongoing criminal investigation. And as DOJ readies its appeal, it's asking Cannon to reconsider her decision, at least for the 100 or so classified documents identified by the FBI. DOJ argues that those documents in particular belong to the federal government, not Trump, and that Trump doesn't have a plausible argument that he has any privilege claims over the classified documents. DOJ says if Cannon doesn't press pause on her order by Thursday, they'll appeal to the 11th Circuit immediately.
This really puts it to the Trump team. Are they going to claim in a court of law that these documents were declassified by the president, the former president, when he was president? Because one answer to this is for them to say, what are you talking about? There are no classified documents. They might bear classified markings, but those were all declassified. I bet you that he doesn't do that because he's not going to want to have that tested in a court of law. And of course, there are criminal penalties for lying to a federal judge. So, but I think it really puts a fine point to the Trump team whether they're going to claim these were declassified.
Now, one big question here is about whether a former president can invoke executive privilege when the current president disagrees with asserting the privilege. Essentially, who gets to decide what's covered by executive privilege? Is it the office of the president, therefore always the sitting president, or is it the individual, which could include a former president? And if DOJ appeals, this issue would go up to the 11th Circuit. That's the federal appeals court that oversees cases out of Florida. Currently, 6 of the 11 active judges on the 11th Circuit were appointed by Trump. The Department of Justice and Trump's lawyers were ordered to submit a proposed list of candidates for the special master on Friday, plus a proposal that hashes out the details of how the special master is supposed to work. And as of this taping, that proposal had not yet been filed. So while we're here, WTF is a special master anyway? Well, as Cannon says, in her opinion, a special master is appointed to, quote, protect the integrity of privileged documents. Essentially, he or she will review over 1,000 documents seized and identify 3 things: personal items that belong to Trump, attorney-client privilege documents, and documents that are subject to executive privilege. A special master basically filters anything out that prosecutors are not supposed to see. There could be legal fights over what the special master ends up identifying, but that's the job description. Now, who could actually be a special master? Well, former judges have typically filled this role. Former Southern District of New York Judge Barbara Jones was appointed special master to review documents seized from Trump's former personal lawyer, Michael Cohen. Obviously, attorney-client privilege would have been a pretty big issue there. She was also tapped to review what the FBI seized from Trump lawyer Rudy Giuliani's home and office last year. So she's certainly a possibility. And given what we already know about the classified nature of what was taken at Mar-a-Lago, the special master is going to need to either already have a top secret SCI security clearance or be able to get one pretty quickly, perhaps someone who had a high-level clearance recently and could get up to speed. Another option, Judge Thomas Griffith, who was appointed to the D.C. Circuit by George W. Bush. He was a judge for 15 years until retiring in 2020, and since then, he served on Biden's Supreme Court Commission and supported the confirmation of Justice Ketanji Brown Jackson. Lawfare's Benjamin Wittes recently suggested that a retired Supreme Court justice could also bring some gravitas to this role. That would mean Justice Stephen Breyer, Anthony Kennedy, or David Souter. Of course, Justice Sandra Day O'Connor is retired from public life. Moving on, but not too far away, actually. Last week, the New York Times reported that a federal grand jury in D.C. is looking into Trump's Save America Pac. Trump founded the PAC after he lost the 2020 election, and at the time, he was raising millions of dollars while touting the false theory of widespread voter fraud. There was not widespread voter fraud, to be clear. But now the grand jury has issued subpoenas to junior and mid-level aides who worked at the White House and on the Trump campaign, according to The Times. The Times reports that these new subpoenas appear to be from a different grand jury than the one that's already investigating January 6th. One is focused on the plan to create a slate of electors who pledged to Trump in the 7 swing states that Biden won. And the other grand jury, according to The Times, appears to be gathering evidence about the so-called fake electors plan. And that one includes questions about Trump lawyers Rudy Giuliani and John Eastman. Now, Trump is now facing federal and state investigations sweeping from Florida to Georgia all the way to New York. And last week, for the first time, a public official was removed for participating in the January 6th insurrection. Cowboys for Trump founder Coy Griffin was convicted of trespassing on Capitol grounds in March. And now a New Mexico judge has ordered that Griffin be removed from his position as county commissioner under the 14th Amendment. Now, that amendment has a clause that says no person shall hold any office under the United States or under any state who shall have engaged in insurrection or rebellion against the same. Griffin's also now barred from holding federal or state office in the future, according to the judge's order. After the January 6th committee's public hearings laying out what the former president was up to before, during, and after the attack on the Capitol, a lot of folks want to hear from Trump's then chief of staff, Mark Meadows. The January 6th committee subpoenaed Meadows over a year ago, and Meadows sued to block the subpoena, and now DOJ has decided not to prosecute Meadows for failing to comply with that subpoena, unlike former White House advisor Peter Navarro, who was indicted in June. Now, this week, a federal judge grappled with the difficult question of whether to order Meadows to testify or block the subpoena, because conversations between presidents and their advisors are privileged. Now, related to that Georgia investigation, last week, CNN reported that new surveillance video surfaced showing a Georgia Republican county official escorting 2 operatives working with a Trump attorney into the county's election offices. Now, that video was reportedly from the same day a voting system was breached in that location. The Georgia Bureau of Investigation is looking into the breach, and this all comes as the Fulton County District Attorney is investigating the Trump team and their efforts to interfere in the 2020 election. And speaking of state elections, we've told you about that big Supreme Court case coming up this term over the independent state legislature theory. We did a whole WTF on it, but basically it's whether state legislatures have the final say over how elections are run in each state, or if state Supreme Courts have the authority over the legislature's decision making. Well, last week, a group representing all 50 states' Supreme Court chief justices, they filed an amicus brief with the Supreme Court. And first of all, it's remarkable that all 50 could agree on anything, I'd say, but perhaps less so is understanding they're defending their power here. They're defending a state Supreme Court's oversight over state elections. And the chief justices across the country urged the Supreme Court to preserve that oversight authority. Basically, they said, Supreme Court, don't get rid of it.